Hi, everyone. Welcome back to my daily episode of California versus Larry Millete, the preliminary hearing from 2023. This case is local to me by way of reminder, and I'm hoping to attend at least part of it in person, so I should be able to have some different kind of insight to share with you than what would be normal for me on YouTube. So today, we're going to come back to the testimony of day one of Desteny Johnson, the receptionist from the law firm, the family law firm that Maya Millete contacted the day she went missing. And obviously, she had no idea what was going to happen to her later that day, but she seemed to share some fears with this receptionist. And right now, we're going to get into the cross examination. Yesterday, we started with the direct. Again, this is the first witness. This is going to be a 10-day hearing, so there'll be lots of episodes every day. So, just a quick note by way of reminder, I'm not monetized, that's by choice. Which means you don't see commercials interrupting these videos, but it also means that YouTube tends not to push out my content as much because they don't make money on it. So if you find this information, useful, informative, helpful in any way, please like, subscribe, do all those things, but especially share this because that's the best way to keep Maya's case top of mind. She is still missing. So, with that, let's get back to our testimony. And again, this is going to start with the cross, and it's a brief bit, and then they break for the day, and then we come back to the next day. So, it's the first and second day that we're getting into today. So, let's go.
And what stands out to you the most about the conversation that causes you to remember it so well?
The fact that I knew that she was looking so forward to the trip with her children, and she didn't get to go.
All right, thank you.
So that was the last thing she said yesterday. This was that Maya was so looking forward to the trip to Big Bear with her family, with her children, with her sisters and brothers, that she was planning. The appointment to come into the office wouldn't be until the following week. And not only did Maya not get to celebrate on the weekend with her family, but she didn't obviously make that next appointment. So let's go. Here we go. Our first glimpse of Larry's then attorney for the hearing. She's no longer, by way of reminder, his attorney, but we're going to have some insights into what she has to say and his case.
Cross-examination. I'm going to be breaking at 11:55.
Thank you, Anna. Good morning, Ms. Johnson.
Good morning.
What time did you call Miss Millete back?
I didn't call Miss Millete back. I believe she contacted our office.
Did you talk to Detective Lorenzo Ruiz on January 11th?
I believe so, yes. I'm not 100% sure on the date, but I believe it was around that time.
Why did you call Detective Ruiz?
Because I was advised by my boss that there was some concerns in regards to her safety and well-being, and that they wanted me to reach out to the police department and just let them know that we had spoke, so if they needed any information, they could contact me.
Why did you wait until January 11th, 2021 to call?
I may have called and left a message prior to that. I don't remember the exact date, but January 11th, do you mind if I look at the calendar? So my best memory of that would be that Monday is my first day back at work. So that may have been why I chose to call on that day, because I was back at work and my boss had asked me to just make sure that I had given some information.
So let me just the chronology of your dealings, communication with Ms. Millete, which would be January 2nd.
Correct.
At around 1:30 in the afternoon?
I believe so, yes.
Okay, and you stated that she was afraid to come to your office?
That is what she had, relayed to me, that she did not want to do her appointment in person.
Was it your understanding that she was still actively employed at that time?
Yes,
Was she going to work at that time?
I believe so, yes.
Okay. And you stated that she was afraid because she did not know the reaction that Mr. Millete would exhibit once he learns about her desire to obtain the divorce. Is that right?
Correct.
She also mentioned to you that she had separated from Mr. Millete before.
Correct.
Did she say when?
No, she just said in the past. If she did, I do not recall.
Is there any reason why she did not list the date of separation on the intake form that you sent to her?
That is not uncommon. People think that if they are still cohabitating, that the date of separation isn't necessarily, that people don't realize that you can pick a date of separation. I can't speculate as to why she didn't, but it isn't uncommon.
Do you normally ask them?
Yes, I do.
And what did she say?
I don't have my notes in front of me, but I believe she mentioned that they had been living separately, but that they were still living in the same house.
When you were speaking to Ms. Millete, did you take notes?
I usually just jot down information. I do have I believe, a note portion, just inside with like very basic notes. But I like it's usually just a handwritten notepad.
And after you spoke to her, you mentioned about speaking to a lawyer in the office, right?
Correct.
Did you hand her any handwriting notes that you had made?
No.
Did the lawyer attempt to communicate with Ms. Millete?
No.
Was she agreeable to meet Ms. Millete by telephone?
Yes.
Did you normally do that in your practice?
It after COVID, it did become, before COVID, we didn't do over the phone appointments unless the parties were separated out of state for some reason. But after COVID, it did become something that we allowed. Is always the preference to come in if you can, but we do over the phone appointments since COVID.
All right. So again, the sound is not great. I'm hoping that if this does go to trial and we don't have a plea, actually a plea would be great. And to find out where Maya is would be really wonderful for the family. But hopefully, if it does go to trial, we'll have better audio. Please use your CC, your closed captions, because it's doing a pretty good job picking up what's being said here. Initially, again, a chilling reminder of what was going on in that law office. It was very public knowledge that Maya was missing. If you were here locally, you would have heard about it. And so the law firm would have known that she was missing. And so they instructed the receptionist here, Desteny Johnson, to contact the police and let them know that indeed they had contact from Maya the day she went missing, or on the 7th. At that point, they wouldn't have known what day she went missing exactly, but they were, as you remember from yesterday's testimony, already on high alert and concerned about the contentiousness, the potential danger that Maya might have been in. So again, it was all just based on a very brief conversation with Maya, having never met her before. And now they're being asked, why was this being done over the phone? Was this common to do this kind of thing over the phone? And I found it interesting. I'm glad she asked that question because so many things have changed since COVID. This was 2021, so it was the thick of COVID right then. And, doctor's appointments, legal appointments that normally are not handled over the phone were being handled over the phone to keep people safe from the virus. So it's just kind of an interesting historical perspective as well that we're getting here.
Were you able to advise Ms. Millete as far as how much the retainer fees would be for the lawyer?
I do always give them, I let them know that the attorney will give them a more firm price, but I do let them know that, these are our general retainers.
So what was Ms. Millete's retainer fee?
$5,000.
Council, we're going to recess at this time. And we'll be back at 1:30.
Okay.
We're to recess until 1:30.
Okay, we're going to take a quick pause and move on to tomorrow. Okay, providing I have this clip in the right order, this is the following day. Again, a little bit of this is cut off. The recordings for the first couple of days were really difficult to find, and actually all of the days were really difficult to find. So here we go. Let's see if I got this right, hopefully.
would give her that kind of advice. I felt that she needed to come in and talk to the attorney to get some steps.
So when you were advocating for her to come and talk to the attorney on January the 8th,
Correct.
was that supposed to be a personal meeting with the attorney?
No, it was still going to be over the phone.
And would that accomplish the purpose of preparing a temporary domestic violence?
That would be up to the attorney to decide and talk with her and give her her options.
And if the attorney decided to do that, would she be required to come in?
The attorney would advise her, I think, whether or not she needed to come in or not, or if it was something we could have to sign, then she could send, over electronic signature.
Okay. When you were speaking to, I believe it was Mr. Rhodes, James Rhodes, you recall that? In June 1st,
Yes.
2022. Yeah, you stated that you sent out an intake form which needed to be completed prior to the assessment meeting. Does that mean meeting personally or just what?
Just prior to the appointment.
So there would be another meeting prior to the appointment?
No, so the intake form we send out to the client, we ask them to fill that out prior to their appointment and send it back to us.
Okay, so do you know why Ms. Millete completed your intake form that day under this question about for what type of legal matter are you seeking representation? She only listed dissolution/divorce. Did you understand why she did not include restraining orders?
No, I do not.
Did you call her and ask her about that?
No, I did not.
And did you understand why she said that she did not have any non-formally documented history of domestic violence? What did you understand her to mean?
During our conversation, she had let me know of, feeling unsafe or not feeling comfortable, not having access to funds, having to go to family members to obtain the retainer because she did not feel that she would be able to do that. So it is not, in my experience, uncommon for people to think just because they were not hit that they had domestic violence. Sometimes people think there needs to be a physical act of violence to constitute that. But again, I can't speak to why she didn't formally report anything.
So during that conversation with her, for what, 15 to 20 minutes?
I think so, yes.
She didn't tell you that Mr. Millete had hurt her physically.
No.
And she didn't tell you any anecdotes of prior or past experiences of some type of physical injuries.
No.
And your understanding about this restraining order that you were so concerned about related to finances and tracking her and didn't want to divorce.
Objection made, calm down.
Do you understand the question?
Not entirely.
Let me tell you. Okay, so now, was it your understanding that your concern for her safety was related to those things that you testified earlier and nothing else?
My concern for her safety was my own impression, was the control aspect.
Okay, let's talk about the control aspect. You had the opportunity to discuss the control aspect with her?
No, just some of the things about not feeling comfortable coming to the office, not being able to feel secure in stating that she wanted to get a divorce, not feeling secure in obtaining money out of her own account to pay for a divorce attorney. To me, those are things that signify that she was afraid.
Okay, and you actually advised her to seek help also from some sort of a free lawyer.
Yes, I
advocate?
usually say that when we are talking about the retainer. If there is a DDTRO and they are unable to afford it, that the courts do offer a free DDTRO clinic. If, the funds are not available to her and she felt like, she wanted to go down there and do that.
Did she follow your advice regarding that?
Not that I'm aware of.
Some of her questions are so extremely odd. You will notice that there aren't a lot of objections for a few reasons. This is a preliminary hearing, not a trial. Secondly, the prosecutor probably wants to get some inside information that she wasn't allowed to ask, and she's going to let this attorney do that. The judge will later on start correcting her. It's really interesting to see how this particular attorney responds when the judge corrects her. And this question right here is rather galling. we're used to blaming the victim in a lot of these cases, but to ask her whether or not Maya Millete took advantage of the legal aid program when she just testified that she made the call, made the appointment, did the intake forms, and said she was going out of town with her children, and then showed up missing, never returned, is really rather galling. And to what end? What difference does it make whether or not she was applying for legal aid? Some of her questions are just really odd to me, and so I'd love to hear what you think, especially if you have a legal background.
When you were talking to her on the 7th of January, 2021, was it your impression that she was at work?
No,
Do you know if she was off that day?
I do not know. I didn't ask her where she was at the time.
Okay. And when you set the schedule for January the 12th,
Correct.
did she tell you she was going to be? When you sent out the intake form for her to complete, did she complete that electronically?
Yes, she did.
I just want you to know that wasn't me. This is the quality of the video that's out there. So I didn't do anything. So there was a little skip there. Not sure what happened.
Did you also send her a privacy policy from Broaden Law LLC?
I believe it's on the bottom of our intake form. Just,
What's that say?
I would have to look at the form.
Okay.
Is that okay?
Your Honor, may I to show her the form? This is part of People's Exhibit, I think number 1.
Why don't you ask her if that would refresh her recollection?
Excuse me, Your Honor?
Why don't you ask her if it would refresh her recollection?
Okay. Would that refresh your recollection if I present that document to you?
Yes.
So this is what I mean about, and the judge is so gracious and so helpful to this attorney. Why don't you ask her if it will refresh her recollection? We see that very rarely with experienced lawyers. She has to be reminded of these kinds of things on the regular. So again, I'd love to hear what you think about her lawyering skills.
May I approach, Your Honor?
You may.
See how together she is with her documents. He was asking her about documents that she didn't even have in front of her.
Your Honor, may I please ask counsel if you listen to the what you gave me this is.
Is it a marked exhibit that's been referred to?
I'm not sure. I'm not trying to find out what Ms. Martinez is. It's just the one that she gave me that we downloaded and showed her again.
Sure, you can use whatever you want to refresh your recollection.
Okay, thank you. Councilman. Yeah, approach, Your Honor.
You may. And identify for the record again what it is you're seeking to refresh your recollection.
For the record, Your Honor, I am going to present this to the witness for to refresh your recollection, and it shows on the top of the document, Golden Rule, LLP, privacy policy.
Take a look at it, ma'am, silently, and then when you're done, you can let us know.
Phew, that was a lot.
Can I continue, Your Honor?
Yes.
Did that refresh your recollection,
Yes.
Ms. Johnson? You recognize that document?
Yes.
Was that part of the document that you had sent to Ms. Millete on January the 7th, 2021?
I believe this is the intake form where she begins to fill out her information.
Could you tell us what your company's policy is?
Objection relevance.
Counsel?
Your Honor, this goes to Ms. Johnson's policy, following the policies and procedures of her company in the intake process, which she has testified today that it is very relevant to show the state of mind of Ms. Millete. As far as secrecy and confidentiality, because she's afraid that the husband might find out.
Ms. Bowles?
I'm not sure my objection is so relevant.
Before I roll, I have a question. Had she retained the services of the law firm at this point?
No.
At what point would it be considered that she had actually retained the services?
Once she had signed her engagement letter and paid her retainer.
May I see the document?
Yes.
All right. I am going to sustain the relevance objection. Again, any privacy issues, it's my ruling that you lack standing to assert such a privilege.
So basically, after all of that, she wanted to have this. She's talking. The defense attorney for Larry Millete brought up the matter of secrecy. So she's talking about how Maya would have been keeping this appointment secret from Larry, which is not something that necessarily this this document is going to show. So after all of that, it was sustained. The objection was sustained on relevancy.
Next question.
Can I take the document back down?
Sure.
Can I question her about the document?
You can move on to another area, but as far as any privilege, I've ruled that there's no standing. Therefore, it's not like it.
When you have a client that has completed the intake form, do you keep that confidential in your office during this last 6 years you've been working there?
Objection relevance.
Sustained.
I believe, Your Honor.
So she'll continue to ask questions. This is not, you're going to see this throughout. I'm just dying to hear what you think. She'll continue to go down that path, even though her objection was sustained on relevancy. And the judge is going to be really great with her until a point, which is just, in the way he handles it, is just wonderful.
She's testifying as to the procedure in taking a complete and reliable intake information, and that's the practice that she has been following.
That's different from asking about the privacy issues. If you want to ask how they retain the records, I'll allow that.
Do you keep the records after you have spoken to a potential client?
As far as the intake forms and all of the electronic communications, yes.
Okay, so you still have those in your custody?
They are still on our computer in our cloud, like our sorry, I call it this Clio.
Um, You believed that a next day appointment was needed for Miss Milete's case, and that you advised her about the urgency. Was it your belief that it was urgent, or was it your belief that it was emergency?
It was my belief that she needed to speak with somebody so that they could advise her as to how to proceed. I believe that she needed an urgent appointment.
Did she describe to you how Mr. Millete was tracking her?
No, she did not.
So the controlling behavior that she described to you was based on the finances, correct?
And not feeling comfortable to come into our office. Not feeling like she was free to do so at her will.
Regarding your testimony about Miss Millete complaining about privacy, did she complain that to you?
I'm sorry, I'm not quite understanding.
Did Miss Millete feel like she did not have any privacy?
I don't recall her specifically saying she didn't have privacy. I don't remember that being a part of our conversation.
Okay. So she was just telling you that Mr. Millete could follow her going to your office.
She never specifically said that he was following her or anything. She just said she did not feel comfortable coming to our office because she was afraid that Mr. Millete would find out about it.
So with the domestic violence DRO that you were advising her, what sort of domestic violence temporary restraining order did you describe to her?
I did not, and I didn't advise her. I let her know that this is an option and that I felt like she should speak to an attorney.
So this receptionist is definitely staying in her lane. She knows that she wouldn't have been in a position to advise, especially somebody who hasn't even been retained yet. The other thing that I just wanted to quick point out on the previous question asked by this defense attorney was about the restraining order, potentially getting a restraining order because of financial abuse. Remember, Maya was definitely a higher wage earner than Larry, but she didn't have any money. She had to stash away money in order to have money for this retainer, according to witnesses. So we'll see about that later. But this attorney brought up financial abuse, and she was trying to differentiate between physical abuse and financial abuse, which, okay.
How did you discover that Miss Millete was missing?
My boss contacted me, or excuse me, there was a voicemail on our work phone, and I forwarded it over to my boss, Marissa Holly. And I don't know, I believe that she may have contacted somebody, and then she let me know.
I'm sorry, she,
Excuse me, Marissa Nahali?
so can you repeat that?
Sure. We received a voicemail to our office line, Guatemala, and I forwarded that voicemail over to my boss, Marissa Nahali. I believe that Marissa Nahali contacted somebody or returned the phone call to speak with somebody, and that is how I found out that there was some concern.
So now, when you called the Chula Vista Police Department, did something prompt you to do that?
My boss, Marissa Nahali, asked me to contact them just to let I had spoken with her.
What else did you tell the Chula Vista Police Department?
I remember speaking to them about having Maya contacting our office to schedule an appointment. I let them know that there were some things in the conversation that I felt were a little bit concerning and that I had set an appointment for her.
Did you describe that you felt that she needed a DVRO?
A DVTRO?
A DVTRO?
To the
To
detective?
to the detective.
I may have said that I felt there was a need for it, but I don't believe I did.
Did you ever say to the detectives that there were red flags of domestic violence?
Yes.
What do you mean by that?
I felt that it was the nature of the call with Maya led my personal belief to be that there were control issues, that she did not feel comfortable coming into our office, that she felt that she was, and this is my opinion, unsafe to seek a divorce. That's why she was trying to keep it a secret.
Did you tell the detectives that while you were attempting to set up a date for Maya to come into the office, Maya or May stated she wanted to wait. So were you trying to set up an office appointment for her?
I just need an appointment with the attorney. So,
Okay, that's what you meant.
yes.
Not for her to physically.
Not for her to physically be there,
Yes.
for her to schedule an appointment.
When there is a telephonic consultation with an attorney at your office, how long does usually take?
Our normal consultation for a new client is 30 minutes. It does go over depending on the issues, but normally 30 minutes.
And did Ms. Millete indicate to you that she couldn't take 30 minutes to call the attorney on January the 8th?
No. I recall.
And in fact, it was Ms. Millete who requested to wait at least for about a week to set up an appointment with your attorney. Isn't that right?
So it was my understanding that she wanted to wait until after the family vacation. So I believe they were returning around that.
You indicated that she was scared or nervous.
She sounded resolute in what she was wanting to do, but she did not seem like she was comfortable making that public.
Meaning,
She was afraid that Mr. Millete would find out.
did you advise her to leave the house at any time?
No, I did not.
Again, she's the receptionist, so she wouldn't have been giving her that kind of advice, but sure. It's day one. Actually, it's day two. It's witness one.
After you spoke to the children of this case, did they indicate to you where they're going to? Did they tell you that they were going to do?
They didn't say anything. They just said thank you, and they would contact me if they needed anything else.
Then it took until June when you spoke to some investigator?
I believe so, yes.
So you spoke to them in June of 2022, I believe? Still recall all the details that happened between you and Ms. Millete in January 7th, 2021?
There are some things I'm not going to forget.
Okay, so,
That wasn't very helpful. That question, she got an answer that she probably didn't want. Again, this isn't a trial, it's a preliminary hearing, but still that impression is pretty powerful.
as far as I can determine from your conversation in June to the investigator, you mentioned about you still remembered of the conversation with Maya that concerned you. So what are those bits and pieces that you talked about?
I remember her not feeling comfortable coming. I remember her not feeling like she was able to pay the retainer out of that Mr. Millete would be able to see. I remember her speaking about Big Bear and her daughter's birthday.
Anything else that you can remember?
I'm sorry. Is there? Give me a second. I mean, right now that's what I have. Sorry.
Okay, so did you receive any additional information in June of 2022 regarding Ms. Millete?
Not that I recall.
How long do you retain the records of your clients at your law office?
We keep the physical files in storage. I believe it is for 5 years. I'm not 100% sure, but I actually think it might be 10 years that we keep them in storage. But we have the electronic records stored indefinitely.
And in the event that I would request those records, would I be able to just send a request to your office and would be provided to my office?
Objection to all of this. You want to still be questioning for people.
Sustained pursuant to Code Section 866A. Preliminary hearing is not to be used for discovery purposes.
What can I ask?
Counsel, you'll have to abide by the regular discovery procedures. The purpose of this hearing is not for discovery.
Can I ask another question regarding that, Your Honor? Is it restricted for your office to provide me a
No,
copy?
you can't ask. I just told you.
Okay, so
You know how to do it. This.
I'm sorry, but I can't with this one. I hope you picked up on that, but she's asking, how do I get a copy of something? Well, this woman's on the stand. call the office, maybe? This is a preliminary hearing, as the judge says. Of course, that was objected to by the prosecutor. But then she basically argued with the judge, can I ask, judge? And proceeds to ask, even though he didn't answer her and say yes or no. And then, of course, it was shut down. But this is how she rolls, this woman. And it's, this attorney. But I just find her so funny. I want to know what you think about this attorney.
It's not performed.
I understand your difficulty is Miss Millete is not around to sign an authorization, or I could request counsel to obtain that for me, I suppose.
Regardless,
Yes.
move on. It's not a legitimate question for it.
I'll redraw the question then.
The question, I've sustained rejection.
No, you can't withdraw the question. The objection was sustained. I mean, come on. So argumentative is she.
It was your understanding that Miss Millete was going to have a trip to go to Big Bear, correct?
Correct.
She told you that clearly.
Yes.
And you believe she was going to go to Big Bear on Saturday?
I don't recall if she told me they were leaving on that Friday, like afternoon, or Saturday morning. I don't remember the exact date that they were leaving and the exact date that they were coming back. I don't remember those exact detailed dates.
And you were speaking to her on that Thursday,
This,
on January the 7th.
yes.
Was it your understanding that Mr. Millete, her husband, was going with her on the trip?
I did not ask.
You described the manner of her speaking to you in, quote, out of the ordinary. Why was it out of the ordinary?
Because it is unusual for somebody to relay that they are unable to come to our office in person because they're not willing for their partner to find out. That is out of the ordinary. Normally, if I set an appointment, people just decide to come.
So she was nervous and yet she was excited when she was talking to you about the trip to Big Bear?
Yes. I'm sorry, I missed the first part of that sentence, but the excited about Big Bear part, yes.
But you were describing her voice, because you didn't see her, just the voice, and you said she was nervous and scared. So how did you determine that from her voice?
So part of my job is to, talk to people. So when we're talking about the things that are difficult and the not feeling comfortable part of coming to the office and setting an appointment and those kind of issues, people, show their emotions. But then when it comes light, I'm a mother too. We talked about Big Bear and, how beautiful it is and how fun, it is with kids at that age. And, so I feel like it was just a way for me to kind of open up and make her feel comfortable, as far as talking. So it's just a natural thing.
After that, you were able to calm her down and she was excited talking to you about the Big
I
Bear
wasn't
trip?
able to calm her down. We discussed, I don't want to say bonded because that's a very strong word, but we related on the fact that we were moms, we went to Big Bear. It was something she was very much looking forward to, spending that time with her children.
In addition to what she had already told you about Mr. Millete.
So again, this attorney starts out by asking this witness to speculate about Maya's emotions, and then now she's saying, how would you know? I don't even know if she has any rhyme or reason to these questions, but I know sometimes defense attorneys can be, crazy like a fox too, and they can get things in unorthodox ways, but I just find her very amusing.
Did she describe him further to you as far as just generally?
I don't remember any particular details about his person per se, just his demeanor.
Did you discuss the child custody?
No, we did not.
Did you discuss spousal support?
No, we did not.
Did she ask you questions about that?
She asked me questions about, believing that there may be accounts that she had no access to or information on, and if there was the possibility, and I let her know that was something that she could discuss with the attorney at her appointment.
So did you understand that Mr. Millete was actually not allowing her to be able to access any of their accounts?
I don't know that I would say that she had no access to any accounts. I know that she said she did not feel comfortable paying a retainer out of an account.
So she never said, I don't have the ability to access any of our joint accounts.
Not that I remember.
Did she express to you any concerns regarding the safety and health of their children?
No.
Did she express to you that she was looking for another place to move in?
I don't remember. I believe so, but I don't remember for sure.
Did she mention to you that she wanted to move out of their house?
I believe she did.
Do you have any more recollection regarding that conversation in reference to her moving out of the house?
No.
Did you have an understanding that she was actively planning on moving out of the house?
No, I would imagine that that would be something that she would discuss more in detail with the attorney when she had her appointment.
When you were taking the intake information based on your job as a manager, you were assessing the issues that you needed to know in order to properly refer her to the right department, you said, right?
Correct.
And those referral to the right department will be based on present complaints, is that right? Her present complaints when she was talking to you.
Well, we have two departments and they're very separate, so it would be a probate matter or it would be family law matter. So it's pretty easy to distinguish, based on those couple of questions, whether it's a probate matter or a family law matter.
She did not express to you that she was interested in trying to write a will or make a will?
No.
Okay. Did she ask you about mortgage and real estate?
No, not that I'm aware of.
She asked you anything about division of community properties?
She may have asked. That wouldn't be something that I would be able to advise her on. So if she did ask, I would have told her that those are questions that she can talk to the attorney about in her consultation.
Did she indicate to you whether they're heavily in debt or having problems with finances paying their debts?
Not that I recall.
Okay. When you terminated your communications with her, did you have a comfortable feeling that she could be left alone?
I certainly didn't expect this. We do family law, so this, I don't hang up the phone with every potential client and go home and worry about them. So, I had my concerns while we were on the phone. I did my best to schedule her in a timely manner that I felt was necessary for her. She made her decision, and, that's all I can do. I won't say that I wasn't concerned, but there's not much I can do after that.
You didn't think you could be useful to her at that point?
No, she wasn't the client, and there was nothing for me to, do in the meantime.
Okay. And you felt you did your obligation and duty towards her?
Objection relevance.
State,
That's all I have, Your Honor.
redirect.
Both questions.
That was just nasty, don't you think? So now she's blaming the receptionist? Okay. This is a preliminary hearing, so okay. I'm not so sure that would be helpful, but again, I'd love to hear what you think as to whether or not that would help the judge decide whether or not there is enough evidence to hold Larry Millete at this point over for arraignment. So we're going to get a redirect, and then we'll be done with Destiny. This is very powerful redirect.
Can I push the next one?
You may. I'm sorry, why? You need something?
Sorry?
Why?
Oh, to show her anything?
Yes.
I'm going to show you People's 22-8. Sorry, Court's Exhibit 22-8. And on the left side of that exhibit is a little box with information looks like related to Broad-in-Law.
Correct.
Is that the correct phone number for Broad-in-Law?
Yes, it is.
Okay, and do you know the number off the top of your head?
Yes.
Okay, what is the phone number?
619-567-6845.
Okay. And you think you testified that you generated the kind of initial email that went out to her, we've already discussed, the forms, the questionnaire, that was done, would you say within about 10 minutes of that phone call?
Yes.
You made a comment on cross-examination regarding your memory of this phone call, and you said there's some things you're not going to forget. What did you mean by that?
It's part of my job to speak to people in some of the most difficult times, and you never expect to hang up the phone and be in a situation where, you know, everything's changed for their family, and there's just certain things about that will live with me forever. I do feel some remorse for sending her an intake form. I feel like that was maybe something that was discoverable, and it has made me question my role. And for that, I'm just not going to forget it.
And is it like what you learned subsequent to your phone call to the police? Is it fair to say that that's also part of why this phone call is distinct in your memory?
Absolutely.
Thank you.
Recross?
So this one.
Nothing?
No.
If that isn't, oh my gosh, if that isn't the most heartbreaking testimony, wow. Really, again, like I mentioned yesterday, a lot of insight here about what goes on in a family law practice, but of course, you didn't expect this ending. I'm getting all choked up now, too. And I've seen this like 5 times. So, with that, we are going to get on to our next witness. So, thank you for joining me for this segment, and we'll see you for the next one. Thank you for being here.